Welcome to this explainer. Today, we are diving into what is honestly a fascinating constitutional tightrope. We're unpacking exactly how the Indian Constitution navigates this incredibly complex, sometimes messy, intersection of personal faith, minority rights, and state reform. It's a really brilliant piece of legal engineering, and we are going to break down the whole shebang, step by step.
Here is our roadmap for the explainer. We'll be hitting 6 key areas. First, the unique Indian secularism. Second, your personal religious freedom. Third, community rights and taxes. Fourth, religion in the classroom. Fifth, protecting minority cultures. And finally, minority educational institutions. Let's get right into it.
Section 1. The unique Indian secularism, equal respect and principled distance. To really wrap our heads around these constitutional rights, we first have to grasp India's specific flavor of secularism, because it's completely different from what you might see elsewhere.
Think about democracies that have this massive, impenetrable wall between religion and state, the strict separation model. The Indian state actually takes a completely different path. It doesn't just ignore religion. While it definitely has no official state religion and offers equal respect to all of them, the state actually holds the constitutional authority to step in. It can regulate the secular aspects of a religion and actively promote social reform and equality. It's really a system of principled distance rather than total isolation.
And this entire concept was cemented in the landmark S.R. Bommai case. The Supreme Court laid it down loud and clear. Secularism isn't just some passing policy. It's literally part of the basic structure of the Constitution. That means even Parliament cannot amend it away. The state is permanently tasked with maintaining absolute neutrality toward all religions.
Moving to Section 2, your personal religious freedom. Article 25 and its boundaries. Let's zoom in from that high-level state view right down to the individual level to see exactly how the Constitution protects you.
So, what does Article 25 actually guarantee? Basically, whether you are a citizen or not, you get some absolute core freedoms. You have the freedom of conscience, the right to openly profess your faith, the right to practice your rituals, and the right to propagate or spread your beliefs. But, and this is a really crucial boundary, as the Revsteinus case firmly established, the right to propagate absolutely does not include the right to force a conversion. Freedom of religion means the freedom to choose, not the freedom to coerce.
But hey, constitutional law is all about rules and exceptions, right? Your freedoms aren't just a blank check. Before religious practice gets full protection, it has to pass through a few strict checkpoints. Does it threaten public order, morality, or health? Does it clash with other fundamental rights? If it passes all those tests, the state can still enact laws for social welfare or to reform the secular, non-religious activities connected to that faith. Let's cut through the legal jargon for a second. When we talk about freedom of conscience, we're talking about your absolute, internal, spiritual autonomy. It is the ultimate personal liberty. It's your right to deeply hold a belief, to change your belief, or, and this is just as important, to reject religion entirely.
Now here's where it gets really interesting. How do judges actually decide what counts as a genuine religious practice? They use something called the Essential Religious Practices Doctrine. Built up through massive cases like Shura-Mutt and Sabrimala, this rule acts as a filter. It ensures that only the core, integral religious rituals are shielded from state interference. If a practice is deemed non-essential or purely secular, like managing the finances of a temple, the state can totally step in and regulate it.
Okay, zooming out a bit for Section 3, community rights and taxes, autonomy and state funding. Let's explore how entire communities manage their own affairs and tackle the always debated rules around money and religion.
If you happen to be part of a religious denomination, which legally just means a group sharing a common faith, a distinct identity, and a common organization, Article 26 steps in to give your community a ton of autonomy. You have the right to establish institutions and manage your own property and affairs, though, keep in mind, just like individual rights, this is still strictly subject to public order, morality, and health.
Which naturally leads us to a pretty spicy question. Can the government actually take your hard-earned tax dollars and use them to promote one specific religion? It's a huge question of fairness.
The short answer? No way. Article 27 totally bans the state from forcing you to pay taxes specifically to maintain any particular religion. It's a bedrock of secular governance. However, the Supreme Court did clarify in the Praful-Gordia case that general welfare spending that incidentally benefits religion, that's perfectly valid. The state just can't play favorites with the Treasury. But wait,
There is a fascinating historical exception baked right into the text. Article 290A explicitly allows annual payments from state funds in Kerala and Tamil Nadu to certain Hindu temple Devaswam funds. Why on earth is that there? Well, it's a deeply pragmatic compromise, honoring inherited historical agreements from former princely states before the Constitution was even written.
That brings us to Section 4, Religion in the Classroom, Article 28, and Secular Education. Let's see how this delicate balancing act plays out in our schools.
Article 28 basically sets up a sliding scale based on who's holding the purse strings. If an educational institution is wholly funded by the state, religious instruction is completely prohibited. Period. If it's established under a religious trust but happens to be administered by the state, then it's permitted. And if a school is simply recognized or financially aided by the state, religious instruction is allowed, but participation is strictly voluntary. You cannot force a student or their guardian, if they're a minor, to participate.
And the Supreme Court hit the nail on the head in the Aruna Roy case, making a really sharp distinction. Educating students about different religions and moral values, that's totally permissible. But state-sponsored religious indoctrination, absolutely prohibited. It's the difference between learning about beliefs and being forced to adopt them.
Let's pivot to Section 5, Protecting Minority Cultures. Article 29 and the right to conserve. This section focuses on protections that are absolutely vital for maintaining India's staggering cultural and linguistic diversity.
Now, before we dig into the rights themselves, we have to ask, who exactly is a minority? Surprisingly enough, the Constitution doesn't actually define the word. But following the Supreme Court's massive decision in the TMA Pi Foundation case, we now know that minority status, whether it's based on religion or language, is determined on a state-by-state basis, not nationally. So you could be part of a majority group in one state, but a recognized minority in the state right next door. So Article 29 acts like a massive shield against forced cultural assimilation. It guarantees that any distinct cultural group has the fundamental right to conserve its unique language, script, and culture. At the same time, Article 29, Clause 2 makes sure that state-funded or aided schools can't have discriminatory admissions. As upheld in the famous Champakam Dora Rajan case, no citizen can be denied a seat in a state-aided school purely based on religion, race, caste, or language.
And finally, we arrive at Section 6, Minority Educational Institutions, Article 30, and Institutional Autonomy. Here is where the Constitution hands minorities actionable tools to actively preserve their heritage.
Under Article 30, Clause 1, religious and linguistic minorities are granted some seriously robust powers. We are talking the fundamental right to establish and run educational institutions of their choice. This means they get to manage internal governance, appoint their own staff, set admission policies, and crucially, they have the right to receive state aid without the government discriminating against them just for being a minority institution. But as you've probably noticed throughout this explainer, autonomy is almost never an absolute free-for-all. As cases like St. Xavier's and Modern Dental laid out, the state absolutely can and does step in to enforce reasonable regulations. We're talking mandates for high academic standards, sanitation rules, and teacher qualifications. The basic rule is this: the state can regulate for educational excellence as long as it doesn't destroy the distinct minority character of the institution.
So as we wrap up this explainer, I want to leave you with this thought. Indian secularism isn't just some static, boring wall. It's a living, breathing, constant negotiation between individual faith, community preservation, and the drive for social reform. Where exactly do we draw the line when these deeply held rights inevitably collide with one another? That is the ultimate question that the courts, and honestly all of us as citizens, must actively engage with every single day. Thanks for exploring this with us.